So our next snippet is going to look at the Gilded Age, oops, outside of the social issues outside of the realm of race. I mean, on race, the Gilded Age is just a catastrophe. In other areas, the message is more of a mixed bag. So the first regards Asian Americans. So there's a kind of importation of Chinese immigrants to the United States in the 1860s, 1870s, 1880s, largely to work on construction of the Transcontinental Railroad, which is just it's a brutal job. And you can see the chart here up to around 100,000 Chinese who were in the United States, including growing numbers of Chinese American citizens. So these would be the children of resident aliens, so Chinese citizens who had entered the United States, but not as citizens. They had work permits, but when they have children under the 14th Amendment, those children are considered American citizens. The increasing prominence of Chinese Americans generates a significant backlash in California, largely through the work of this party, the Working Men's Party, headed by this guy, Dennis Kearney. The Working Men's Party is a state party, but it sometimes supports the Republicans, sometimes supports the Democrats. We would see it now as a kind of right-wing populist party. Its agenda is to exclude Asian Americans from participation in American life, sort of like what happened to African Americans in the South. Now, you would think this is a small party. It's California is not a large state at this matter. Why would Congress care? Well, you can get a sense of why they care from this map. Politics in this period, the Gilded Age, so 1876 till 1896, is very polarized. Most states which are Republican states, red on this map, are states that vote Republican in every election. Most states that are Democratic are states that vote Democratic in every election. But there are a handful of states, California, Nevada, Indiana, Pennsylvania, which are kind of swingy states in this otherwise very tightly partisan system. And so the fact that California is a swing state tempts both the Republicans and Democrats nationally to try to kind of play footsie with Kearney support anti-Asian racism as a way of winning California's votes. And the result is the first piece of immigration restriction legislation in American history, the Chinese Exclusion Act of 1882, which prohibits Chinese laborers from coming to the United States, and is passed largely as an effort, to appease the xenophobic forces in California, with both parties hoping that they would be able to appeal to voters in California. This, as in the South. So in the South, we see these laws that discriminate against African Americans, and then there's social customs that do as well. Same thing happens in California, but here the Supreme Court does stand up on behalf of Asian Americans. If you were cynical, you could say they're doing it because powerful corporations like Asian labor, which they see as driving down the labor costs, but nonetheless the court does enforce the 14th Amendment correctly in this famous case called Yickwo versus Hopkins. So the issue here was a San Francisco statute, which was neutral on its face. It claimed that they were acting just for public safety purposes. They dealt with laundromats, and they said that laundromats needed to be built with brick rather than with wood, because they're worried about earthquakes. And coincidentally, most of the Asian owned laundromats were built with wood. And when Asian owners tried to get permits to build new laundromats, the city denied it. So basically, this was a law that was facially neutral, but practically was designed to punish Asians. And the Supreme Court in 1886 says no. They said, look, this is an obviously discriminatory law. As an obviously discriminatory law on the basis of, in this case, ethnicity, it violates the 14th Amendment. And this is a kind of shining light decision in a pretty dark period in American history with regards to equality, and it's a decision that will frequently be cited in the 20th century. Similarly, in the late stages of the Gilded Age, there's movement in favor of women's suffrage. So this is Susan B. Anthony. This is a public protest on behalf of women's suffrage, and very slowly, territories and states start to permit women to vote in their areas. The first two territories that permit this are Wyoming and Utah. They do it for entirely practical reasons. These are territories where there's a significant disparity between men and women. And so the idea is to encourage women to go to these territories, because the argument is, you'll have full political rights. Idaho and Colorado, the state of Colorado, in this case, the territory of Idaho, quickly follow suit. And in the early 20th century, a handful of other Western states, this is previewing what's come a little bit, but these are states that have a strong progressive era impulse, enact women's suffrage. So there is a degree of movement towards women's equality in this period. Similarly, there's a very powerful public interest group run by women with very gendered language, called the Women's Christian Temperance Union, which has hundreds of thousands of members. Its chair is this woman, Frances Willard. It calls for temperance. It does so on gendered grounds. The argument is that women have a particular obligation to promote temperance, because they're threatened by domestic violence from abusive husbands who abuse alcohol. B, women's job is to protect the home, and husbands who spend all their money on beer and in the saloons won't be able to protect the home. And third, the idea is that temperance protects children. These are arguments that the temperance movement is basically a social conservative movement, but it's a striking movement in that it's really the first major issue movement in American history where women are front and center and women are playing the dominant role. Now, there are some limitations to this era, and the most striking comes in the area of the law. This is Belle Mansfield. She's the first female lawyer who's authorized to practice in the United States. She was from Iowa. Another female lawyer in one of our groups read this case. So when Myra Bradwell is denied the right to practice law in Illinois, and there are some technicalities in the Bradwell case, but the case is remembered. She eventually appeals to the Supreme Court, saying that she's being discriminated against under the 14th Amendment. The case is best remembered for a concurrence written by Justice Bradley. The court says that she has no right to practice law in Illinois. And Bradley, in his concurrence, as you can kind of see from the screen and the areas that I have here in red, basically says, women aren't equal, and that it's perfectly reasonable for states to enact restrictions that deny certain professional livelihoods to women. So, I don't want to overstate this period in terms of social equality outside of the issue of race, because there are real limitations. But in a handful of areas, there is some movement in the aftermath of the Civil War. The spirit of the 14th Amendment does animate itself, but not on issues of race.